hearing the Court of Appeals of the State of Michigan is now in session. The Honorable Mark P. Boomstrom, the Honorable Seema G. Patel, the presiding Honorable Chief Judge Michael F. Godola. All persons having business in the hearing draw near, give attention, they shall be heard. God save the United States, the State of Michigan, and the Honorable Court, please be seated.
Good morning. A relatively full house this morning. Good to see. On behalf of my colleagues, Judges Boomstra and Patel, welcome to the Michigan Court of Appeals. This is panel 5 in Lansing. I'll give my usual admonitions, I guess, to the lawyers or advice. We've read your briefs. We've had reports from our staff on all the cases we'll be hearing today. So you don't need to belabor the facts. Just cut right to the most decisive legal issues and let us know as succinctly as possible why you should prevail in your appeal today. In cases involving minor children or protected individuals, please use initials only, not proper names, as these proceedings are being recorded and will be uploaded to YouTube within the next 24 hours or so. With that, I think I can call the first case of the day. That is item 13, docket number 374696, CMS Energy Corporation versus Department of Treasury. And I'll just ask whether you're dividing time. You have 30 minutes per side, inclusive of a rebuttal. I'll just let you know. And so whoever wants to go first can jump up to the podium and let me know how you plan to proceed. Let us know. Yeah.
May it please the court. Good morning, Your Honors. Maria Todorova for CMS Energy Corporation. Thank you for allowing me to appear today. I'd like to reserve 7 minutes for rebuttal, please.
Sure.
Your Honors, this case is about where to source CMS's wholesale sales of electricities to out-of-state utilities under Section 206-665-1A of the Michigan Income Tax Code. The tax tribunal held that all of those sales must be sourced to Michigan, not because any Michigan utility bought the electricity and not because the electricity stayed here, but simply because the interconnection point, which is the location where CMS's electricity enters the transmission grid, is located in Michigan. The tribunal's holding is wrong for 2 primary reasons, and that's what I'd like to focus on today. The first reason is the tribunal held that MISO is the purchaser of electricity. And the second reason is that the tribunal concluded that the ultimate destination is the interconnection point is the ultimate destination where the electricity is delivered to MISO. Neither holding could be squared with the statute or the record. To understand why these holdings are wrong, I would like to begin with the plain text of the statute itself in 206-665-1A. Looking at the plain text, a sale of electricity is sourced to Michigan only if 2 things are true. Number 1, there must be a purchaser, somebody who takes ownership of the electricity and somebody who pays for the electricity. Number 2, the purchaser must take delivery in Michigan, meaning Michigan must be the electricity's ultimate destination where it comes to rest, not a transit point, not a routing point, and not based on any conditions of the sale or any FOB mechanics. So what we have here, what we have in 206-665-1A is ultimate destination rule, not a point of entry rule. Your Honors, allow me to give you a simple example of how this works. An Ohio gas company, producer, selling gas to customers in Michigan. It hires a dispatcher in Ohio to coordinate truck deliveries, collect payments, and settle the parties' monetary obligations. It also takes momentary title to the gas in Ohio for purposes of settlement. Would Treasury agree that 100% of those sales must be sourced to Ohio?
Of course, this isn't gas, it's electricity, which is different.
It is different, Your Honor, but for purposes of the statute, gas and electricity are treated exactly the same. In fact, the plain language of the text says for sales of gas and electricity, which is why the analogy it applies in the case of electricity as well.
I guess my question or my point or question is, by its nature, it's impossible to know what the ultimate destination of the electricity is, because in this case, it's transferred to MISO, which accepts it within Michigan. Some of that, the bulk of it, is sold back to CMS, that which comes from CMS, as I understand it, and a portion is sent to other states within MISO. How do you know, given the nature of MISO, and it's accepting, has these tariffs with multiple states, right? You can't segregate the CMS electricity from all the electricity. It comes into one pot, if you will. So I'm not sure how you would calculate what the ultimate destination is.
That is an excellent point, Your Honor, and allow me to explain. As you pointed out, electricity and actually gas are different than widgets, the tangible traditional goods, because we cannot trace molecules of gas or electrons of electricity exactly in terms of, what electron ends up where, which is why the legislature envisioned that for purposes of sales of gas and electricity, we start with the contract, or we start with the document, because they acknowledge that for sales of electricity and gas, there's not a bill of lading, there are no shipment notes that would tell you where the ultimate destination is. So we look at the delivery instructions, but we always measure that where delivery is based on ultimate destination. Now, to respond to your question, where electricity's ultimate destination is in this case is we are only focusing on electricity, wholesale sales of electricity from CMS to other utilities that are purchasing through this federally mandated market that's operated by MISO. Now, the sales of electricity, the subsequent sales of electricity that you referenced when CMS buys electricity, those are separately accounted for. And in fact, those are not an issue in this case. They're sourced based on where the location of CMS's customers are. So for purposes of the sales here.
For out-of-state purchases, those other states within MISO are purchasing from MISO. They're not purchasing directly from CMS, correct?
That is incorrect, Your Honor.
Okay.
And here's why this matters. The first, and this is a critical point, MISO cannot be a seller or a purchaser under federal law. That is crystal clear. MISO is charged by the federal government, by FERC, the Department of Energy, with operating this organized wholesale market. That's the law. And in that capacity, MISO has to remain neutral. To remain neutral, MISO is prohibited from buying and selling electricity. It just simply does not buy electricity.
But it works the same way in both directions, right? So MISO would be as you would put it, the pass-through entity with respect to a sale as well, right? So if Louisiana purchases electricity from MISO that happened to come from Michigan, they wouldn't send money directly to CMS for that electricity. I don't think the money would go to MISO and then to CMS, would it not?
Actually, Your Honor, that's an excellent point, and I'd like to clarify. MISO acts just like an escrow agent, just like a clearinghouse. So what happens is, first of all, MISO has to clear the bids that come from the sellers or the buyers. So in your example, if the Louisiana utility doesn't need electricity, there will be no sale. You have to have a buyer in order to have a seller. So now let's say that there's demand, and the Louisiana utility transfers the money, to your point, to MISO, but that money is held in a trust for the benefit of the seller. MISO has no ownership to the money. It has no title to the money. It takes no cut from the transaction.
Is that the document? Is there a document that undergirds that transaction, also known as a tariff, when there's a purchase? Is there a contract, let's put that in quotation marks, between Louisiana and MISO when they're purchasing electricity?
There's no separate quote unquote contract, Your
There's
Honor.
no tariff?
This is very important. So the tariff that it's referenced throughout the briefing, it governs all the parties.
Okay, is there a tariff between Louisiana and MISO when
It's the same tariff.
Louisiana is purchasing electricity
It's the same.
from MISO?
I'm sorry,
Is
apologize.
that a yes? That's a yes or no?
No, it's the tariff that governs the sales by CMS
Okay.
on the market is the same tariff that governs the purchases by the Louisiana entity.
Okay,
And
so I think you were explaining how that works and when I cut you off, so maybe you can get back to
Uh,
how the purchase
absolutely.
transaction works.
So MISO is not the purchaser under federal law. And in fact, if we look at the tariff itself, it confirms that point very clearly. It says it uses the term transmission provider. That's a defined term. And that it says transmission provider MISO is the transmission provider. And the buyer is somebody entirely different. It's the receiving party. That's also a defined term. And the seller is the delivering party. Another reason why MISO cannot be the purchaser, as I explained, it pays no consideration. The money that goes between sellers and buyers is just like an escrow
To
agent.
whom does the receiving party send its money?
To the receiving party, it sends it to the delivering party to use the terms of the
Directly.
tariff.
Directly.
It sends it directly in a sense that MISO is designated,
Sends it to MISO, doesn't it? And
it
then-
goes through, just like a clearinghouse or
Okay.
an auctioneer.
Okay, just answer the questions. Okay, go
Yes,
ahead.
yes, Your Honor. It goes through MISO because that's what the federal government requires it to do. If CMS, if the Louisiana entity wanted to pay CMS directly, they just are not allowed to do that under federal law. It's just required. Another reason is and this is found on page 46 of Treasury's appendix. Treasury's own expert admitted that the purchaser is the entity that withdraws the energy, the electricity from the grid. And that's not MISO here. Again, the MISO is the transmission provider. It's the receiving party that withdraws the energy. At the end of the day, Your Honors, MISO is no more the purchaser of the electricity, that the New York Stock Exchange is the purchaser of every share of stock that is sold in its platform. The New York Stock Exchange facilitates the trades, it clears the payments, it's responsible for settlements if a party defaults, but nobody would say that the New York Stock Exchange buys stock. The same is true here. MISO simply performs its federally mandated duties of settling these transactions, these sales between buyers and sellers, and it cannot buy electricity. The second point why the tribunal got this wrong, the second reason is because it treated the interconnection point as the ultimate destination. That was a misstep because what essentially happened is the tribunal stopped reading the statute after the words purchaser within the state. So the words that speak to ultimate destination, come to rest, regardless of FOB or condition of the sale, the tribunal completely ignored those words. And I'd like to explain. Here we have, the legislature used three critical phrases: ultimate destination, which is the final place, comes to rest, the journey ends, and then regardless of FOB or conditions of the sale. So it tells us we must ignore transactional mechanics. When we read all those phrases together, it becomes clear that electricity is sourced to where the electricity ends up, not where it enters the transmission grid. Ultimate means final, nothing more, nothing less. Indeed, the legislature doubled down on that point. If we read the statute, subsection 1A further down below, it has a provision that tells us that electricity held in transit or property held in transit for less than 60 days in Michigan does not reach its ultimate destination in Michigan. When we apply this framework to the facts in this case, the interconnection point, which again is where CMS enters the transmission grid, the electricity, which is the loading dock, simply cannot be the ultimate destination. If we treat that starting point as the finish line, the statute would be collapsed. The requirements of the statute would be collapsed, which is not what the legislature intended. But yet, that's exactly where the tribunal ended up. And that is striking, Your Honors. And it's striking for two reasons. The tribunal specifically admitted that determining ultimate destination governs here under 206-6651A, and also agreed that that is a necessary finding in this case, yet it ignored it. So you may ask, where is the ultimate destination, which I believe Your Honor was alluding to earlier. The record shows that CMS provided evidence, submitted evidence of certain reports filed with the federal government and other information, which shows exactly where the out-of-state utilities are in those destination points. And based on that information, we see that about roughly 19% of the electricity ends up in Michigan, and that's how we sourced it, but the rest of it ends up outside of Michigan. The tribunal acknowledged some factual disputes on this point, but rather than address them, or rather than conduct an evidentiary hearing, which Treasury itself thought it was necessary, it simply defaulted and it stopped at the interconnection point because, in its view, that's where MISO takes the so-called flash title under the tariff. I'd like to explain a little bit about this flash title construct. We submit that that has little relevance in this case. And the reason is, there are a couple of reasons. The first reason is when we read the tariff or any other agreements that govern the MISO market or the market that's operated by MISO, there's no mention of the word tariff. That is simply shorthand that is used to describe MISO's role as created by the federal government to protect from bankruptcy, settle the financial obligations of the sellers and the buyers. Number two, and maybe more importantly, is when we look at the statute, again, it tells us to ignore title. It specifically says FOB and conditions of the sales do not matter, full stop. The interconnection point is both. It's an FOB point because it's where the electricity simply enters the transmission system, so it's the on-ramp onto the highway. And then it's a condition of the sale because that's what the federal government requires MISO to do for bankruptcy protection purposes. Now, if the tribunal wanted to rely on the tariff to determine ultimate destination, it just stopped at the wrong point. It shouldn't have stopped at the interconnection point. When we look at the tariff, and these terms are referenced on page 7 of our reply brief, the tariff clearly designates a point of delivery, which is, it defines as the location where electricity transmitted by the transmission provider, which in this case is MISO defined, is delivered to the receiving party, which withdraws the electricity from the grid. Now, had the tribunal conducted an evidentiary hearing, the evidence would have shown that all of those destination or points of delivery are outside of the Michigan. And even if MISO were deemed to be a purchaser, as Treasury alleges, which again we submitted is not, the interconnection point still cannot be the ultimate destination. And that's because the statute tells us to ignore title and measure delivery based on ultimate destination. And the tariff then tells us where that ultimate destination is. It's that point of delivery where the buyer withdraws, the out-of-state utility withdraws the electricity from the grid. That brings me to Treasury's fallback, Your Honors. Treasury makes this point that CMS's electricity, almost all of it, stays in Michigan and never leaves the state. That's a disputed fact. But it's also wrong. How do we know it's wrong? Because the Michigan Attorney General and the Federal Energy Regulatory Commission, the federal regulator, told us so 6 months ago, and we referenced this in footnote 1 of our reply brief. 6 months ago, FERC issued an order which related to the allocation of costs associated with CMS's operation of its Campbell plant. In that order, the FERC recognized expressly that CMS's generation of electricity serves utilities across multiple states, not just utilities in Michigan. And if the federal expert believes that multi-state utilities, that utilities benefit in multiple states, how could Treasury credibly argue that almost all of CMS's electricity stays in the state? Again, that's a disputed fact, but just wanted to address it.
Is it disputed? I mean, did the FERC say what percentage leaves Michigan?
It did not say. What's disputed is Treasury's
It
allegation.
said something that we all already know, that CMS sells electricity that leaves the state. I don't think that is disputed.
Well, Treasury specifically says that the electricity doesn't leave the state. In their briefings, they say that almost all of the electricity physically stays in the state of Michigan, and that
Right,
is
80% or more, as I,
correct.
yeah.
That is based on their expert. I believe it was close to 98%, Your Honor.
Okay.
Is what they're alleging, and that's inaccurate, and therefore it's a disputed fact. Your Honors, the bottom line is this. The tribunal acknowledged that ultimate destination was essential in this case. They had to determine ultimate destination, but then declined to make that determination. It stopped at the loading dock and called it the ultimate destination. That is not statutory construction. That is statutory rewrite. In conclusion, the tribunal committed two errors, which I discussed. Both of these are reversible, and we therefore respectfully request that you reverse the tribunal's decision. Thank you for your time. I'm happy to answer any questions.
Any questions for counsel? Okay, I don't think we have any more at this time. You do have time for rebuttal.
Thank you very much.
Good morning, Assistant Attorney General Wesley Margison, representing Treasury. There's a back and forth about where electricity goes and tracking electricity is difficult, but the legislature gave us a simple answer. And it's in the first part of the statute, which is that sales of electricity and gas are different. You look to the contract, and we have a contract here, and that's the tariff. And the tariff, CMS agreed to be bound by its terms. There's an agreement between it and MISO where the tariff terms are incorporated into that. And they also have signed a contract with two transmission line providers dictating that the point where it's going to have its electricity transferred to MISO will be interconnection points within Michigan. Opposing counsel mentioned something about the tariff and the point of receipt. That's backwards. The tariff is written from the perspective of MISO. So we need to look at the point of receipt to MISO in that tariff. And the point of receipt to MISO is these interconnection points in Michigan. There's also a discussion about whether MISO is a purchaser. MISO is any purchaser under the terms of the statute. Under the tariff, they're a counterparty to the transactions. And the definition says they're a counterparty as an independent principal and not as an agent of somebody else. And also we have the FERC reports that CMS has provided that say that MISO is a customer. Those reports say these are sales to MISO. So we have a simple answer in that MISO purchases the electricity, although it turns around and goes other places. But Michigan addressed that by putting special language for the sales of electricity and gas in the statute.
So, Mr. Margison, how do you counter opposing counsel's reliance on the language in the statute? And I'll begin sort of midstream, to any purchaser within this state, and then based on the ultimate destination at the point that the property comes to rest, and then regardless of the free on board point or other conditions of the sales.
In this case, they're one and the same. There's nothing between CMS and MISO. That language is there to ignore things or disregard things between the seller and the purchaser for purposes of the statute. There's nothing between them, so there's no facts to apply here where that's going to have any effect. They're the ultimate destination for a sale to any purchaser because they're a purchaser.
What's your response to the argument that federal law, FERC law, precludes MISO from being a purchaser?
The terms of the tariff say different. It says that they're receiving it. They're a counterparty to the transaction. They're the ones giving money to CMS. The FERC reports say that these are sales to MISO. So we have the contracts that tell us, at least for purposes of our sourcing statute, that they are a purchaser. They're any purchaser.
You can proceed.
Okay. Also, there was no discussion about the Commerce Clause argument, but Treasury's position is that doesn't apply here. They can't show any sort of internal inconsistency because there's nothing in the record that shows that they're being double taxed on this. We asked in discovery, we have nothing that shows they're paying tax in any other state within the MISO footprint. And also, if we tax every state the same way, it'll come out where no one is taxed in any state other than where they deliver their energy to the interconnection point. Unless the panel has any other questions, I will rest on my brief.
Any other questions? I don't think
Thank
so.
you.
Thank you.
And Treasury does ask that the panel affirm the decision of the tax tribunal.
Thank you. Council?
Thank you, Your Honor. Just a couple of points. First, I just wanted to make one correction. I think I misspoke. When I was talking about the title and the appearance of the word title, that does not, I think I said tariff, doesn't appear in the tariff. What I meant is the word title does not appear in the tariff or any other agreement governing the market. I'd like to address 3 points opposing counsel just talked about. There's much discussion about whether the tariff is a contract. We don't believe the tariff is a contract in the sense the legislature used the term in the statute. And the reason why that is because it's really not bargained for exchange. It's not negotiated. It's, you know, the simplest example I could come up is if I start driving on the highway, I have to follow the speed limit, but I didn't negotiate that speed limit. Nobody asked me whether I agreed to it. I'm just bound by it. And that's exactly how the tariff.
Well, you agreed to it by volunteering to drive, right? Like that was the option.
You're absolutely correct, Your
So
Honor.
by being in this energy market, you're agreeing to these terms. That is part of the negotiation, right?
Your Honor, it's not negotiated in terms of, you know, what rules the sellers or the buyers might have wanted. These rules are really imposed by the federal government, and in areas such as MISO, where it's an organized market, the buyers and the sellers of wholesale electricity, they have no choice. They have to operate on this market. They couldn't have what's called a bilateral contract, which this provision, this language in the statute might have been intended to address, is when you have a seller and a buyer entering in a bilateral contract. So you have 2 parties that are negotiating the terms. They're negotiating where title transfers, where the point of delivery is. In an organized market such as these regional transmission operators markets, there are a few of them throughout the country. MISO covers the 15 states that are within its region. There's another one called the PJM that covers Pennsylvania and some other states. It doesn't work the same way as a bilateral contract, but
I'm not sure that the fact that terms aren't negotiated matters with respect to whether or not it's a contract. I mean, we all have contracts of insurance. We don't typically negotiate the terms with the insurance companies. We take what they give us, and they're contracts nonetheless. So
that's a fair point, Your Honor. At the end of the day, whether we call the tariff a contract or not, the entire federal framework of how organized wholesale markets for electricity sales work is really the contract. But whether it's the contract or not, it doesn't change the fact that the interconnection point cannot be the ultimate destination for the reason that I explained. Opposing counsel made the point that MISO is described as the counterparty. That has little relevance here. Counterparty, that is just a designation for settlement purposes. It's very clear that MISO is the transmission provider. That's a defined term. It's just in charge of transmitting the electricity. That's all it does.
Well, it's a little bit more, right? It goes a step further because that's what protects against possible bankruptcies.
Absolutely.
Right? So
Yes.
it does have some legal significance in terms of more than just a clearinghouse.
Absolutely. A clearinghouse or an escrow agent works much the same way, Your Honor. It's intended to settle the party's financial obligations in case there's default or otherwise. And in fact, the reason why MISO is the counterparty here is that the federal government was concerned that, and that used to be the case, they were not a counterparty. And so if there's default, there was not a mutuality of obligation. It's bankruptcy law. I'm not an expert in bankruptcy law. And that's exactly why it's a very limited reason why MISO was made a counterpart, but they're a transmission provider. It's curious that opposing counsel characterized, Judge Godola, you asked about the words in the statute after with purchaser within the state, ultimate destination come to rest, regardless of FOB or condition of the sale, and opposing counsel said that they're all in the same. They're absolutely not all in the same. If the legislature wanted to stop it, delivery to a purchaser within the state, that they would have done so. In fact, they focused on ultimate destination, and that is entirely consistent, Your Honors, with the purpose of a statute like this. This is a sales factor statute. The sales factor statute is intended to find the market. Where is the taxpayer servicing customers, and where is the revenue made? If we don't focus on ultimate destination and simply focus on, mechanics like title, that would turn the statute on its head, because as we all know, title provisions are easily manipulated, and the parties would be able to change, where title transfers. That has nothing to do with the market. So the Treasury's position here is entirely inconsistent with what the legislature intended here with the sales factor. That's all I had.
Anything else?
That's all. Thank you
All
so
right.
much.
Thank you very much. Appreciate your arguments. The case is submitted. All right, that brings us to item 14, docket number 376242, Justin William Horizi versus Amanda May Horizi. Yes.
Good morning, Your Honors. Thank you for your time. My name is Becky Bowles. I'm here on behalf of the appellant, and I would like to reserve 5 minutes for rebuttal.
Sure.
In the event it's necessary. I don't plan on speaking for the whole time, but we shall see if there are questions.
Just might be. You never know.
Okay. So for this one, this case is obviously a post-judgment custody case where the judgment of divorce was entered in 2021. The hearings were throughout the year of 2025. There are a couple of problems throughout the trial that I see as errors for this court, hopefully to help us resolve by setting aside the order and allowing us a new trial. First would be the school records that were admitted under MRE 8036. And this becomes a question of whether or not a party can testify as an other qualified witness for school records. MRE 803 obviously requires either testimony of a records custodian or a certification. I would assert that in this case, neither one of those were done. The attorney for the appellee used the father as an other qualified witness. Now, there may be times when somebody can be a party and can testify about business records, but that would be only if they could meet the other obligations under 8036, that they could testify that the record was made at or near the time, that the record was made in the regular course or activity. And the other factors, the plaintiff father could not do that in this case. So the court allowed a party as an other qualified witness under MRE 803 without being able to substantiate, to testify of the other requirements. If we opened up MRE 803-6 to parties who haven't participated in business, we could have imaginable items that they could testify to where they're not actually qualified. The records were school records. They were not records that he owned a business of. Those records were substantially relied upon on the court, both for a change of circumstances, but more importantly, in the best interest factors and findings to change custody. The other
Was it disputed in the case that the child had attendance issues at one point in time and that those improved later on?
Okay, there's a couple parts. There was no, so I'm going to answer that in a couple of parts. There was no dispute that at one point, one of the children had attendance records because there was a truancy issue. The dispute came after the truancy to the time of trial. Was there problems with attendance? That was disputed. So hopefully that answers your question. Part of it was acknowledged that in 2023, there were attendance issues, but from middle of 23 to 25 during the trial, that was disputed.
But
Okay.
to Judge Boonster's point, the truancy issues abated when custody shifted to father, correct?
No, the truancy issues abated in mid 23. So, and they are, so if in 21, my client was granted custody.
Right.
In 22, end of 22 to 23, there became issues with attendance. From 23 to 24, into 24, the children were not with they were under the every other weekend with an extended Thursday.
Okay.
And then in 24 to February 24 to October of 24, they were with the father, which was a lot of summertime. Then from 24 through custody, they were back with the mother. So there's periods in there back and forth where custody, the absences were disputed other than the truancy section. And then I would dispute the notion in opposing counsel's brief that the father didn't have trouble getting to the child to school, because from that one child in 2023, both parties had trouble getting the child to school. From January and February, the father also could not get the child to school.
I guess what I'm wondering is, how did the admission of the school records make a difference in terms of issues that were disputed?
There was these records that were admitted, one from a printout, two from the testimony was an email that came from the father, got stapled to some of the other ones admitted. So the difference is these records should not have been admitted in that manner. We had nobody to testify what some of these notation means. So if your child, this is for example, if your child is a child who is in sports or an activity and they have to leave the end of school, it's noted in their attendance record. We have no testimony about what the different designations meant for why they were out of school. They all got placed on my client in the opinion as being her fault, even though some of them were not full days and they weren't explained. It could have been he had to see the doctor. It could have been he had to go to band. It could have been a child goes to sports. There can be all of these things that result in these attendance records. There was handwriting by the father on these records. They were mixed between being something he said he printed off of an app and what was emailed by a school official. And clearly the attendance records were an important issue in the case in terms of the findings of the best interest factors. All right, moving on. The other issue that was problematic was the court implemented a blanket rule that at no point was anything prior to 2021 allowed to be testified about. This blanket rule resulted in my client having the inability to testify about domestic violence that happened just years prior. Now I understand that the court may be able to take into consideration the length of time and the things that might have happened. Say it was 2005 and now we're dealing with 2025. The court may consider that in terms of weight. But here we had things that happened in 20 and 21 that we could not talk about that then impacted things just a couple of years later, 22, 23, when the children started to have problems. If we were not allowed to testify about anything prior to the entry of the last order, we would have issues with getting in most domestic violence Domestic violence typically would happen when the two parties are still together. It still has an impact on the children. In this case, the children saw the domestic violence, but we were unable to testify about that. The domestic violence is a factor when you have something such as a change of domicile, which once you've left the home, there are times when domestic violence takes place. So once you have a separation and judgment of divorce, usually the domestic violence took place at the time the parties were together. There are instances where it continues, but we would have this blanket rule that nobody could ever testify about domestic violence. Nobody could ever testify about somebody's potentially severe criminal convictions prior to the entry of the judgment of divorce. I don't think it's consistent with the law, and I don't think it's consistent with such factors as having domestic violence in the best interest factors, nor in like the change of domicile, where you also would evaluate whether domestic violence was a factor. Both of those two things became very important in the change of custody. Then there were the best interest factors that are impacted by the two prior things, the allowing of school records to be entered without an actual custodian of the records, and by not allowing the court to have a full picture of what was going on mere years prior to the entry of this change in custody. And then I have other arguments as well in the best interest factors. I think I will rely on my brief on those unless somebody has question, any of your honors have questions with regards to those. Thank you for your time.
All right, you have time for rebuttal.
Good morning, Your Honors. Jordan Ayler-Smith on behalf of the appellee father. Judge Boonstra, I'm going to start with the question that you asked about what effect the admission of the records had on this case. And in my opinion, I don't know that the actual records themselves made very much of a difference at all. I think that the trial court relied mostly on father's testimony and the testimony of mother, where, you know, she did acknowledge that when in 2023, when one of the children was truant, that was when he was in mother's sole care. He refused parenting time with father as of February of 2023. And a week after he was released from his truancy matter, he missed another week of school and then was issued another letter saying that he was approaching truant. I think that there's a plethora of evidence in this case outside of the school attendance records that shows that these children did have issues with attendance pretty consistently when they were in mother's care. And father testified that he didn't have the same struggles, and the trial court credited that testimony.
It's largely undisputed, I think. I heard you say, and that's my view of it. Is that right? That mother admitted essentially that these truancy issues existed, hard not to.
Correct, right? The trial court took judicial notice of it. Mother didn't object to that. I think that overall the parties do agree that the children had attendance issues. I think the dispute is between the parties as to whose fault it was, which I think in this case, the evidence does tend to show that the children had more problems attending school while they were in mother's custody than in father's. In terms of the trial court's limitation of evidence, I think that when we're talking about a post-judgment change of custody, we do have to look at what's relevant. And I think what was relevant here was the fact that there were more recent allegations of domestic violence in mother's home that were directly relevant to not only the attendance issues, but also why the children wanted to not attend parenting time with father. I believe it was in one of the CPS reports that it was reported that the middle child, the one who had the truancy issues, said that he didn't want to go to school because he had to be here to protect his mom from her ex-boyfriend who, although he was not around at the time the order was entered, he was still having contact with the children after they had witnessed, you know, these sort of domestically violent incidents. And I think that when we're talking about, you know, this alleged domestic violence that happened, you know, many years before with father, I think the more relevant evidence and the evidence the trial court credit is the fact that there was no real evidence that the children were fearful of father. CPS investigated every time that there were these incidents that occurred with parenting time exchanges, and they found no wrongdoing on father's part. And I think that when we're talking about the trial court's discretion, it's broad. And I think that in this case, the trial court did not abuse its discretion.
Trial court didn't say it wouldn't consider the issue of domestic violence between mother and father. it would consider it wasn't going to allow new or additional testimony because it was already in the record from previously. From
Correct.
the initial custody determination.
Correct, Your Honor. I believe if I'm remembering the record correctly, the judge said, I'm going to review the file, and all of that testimony was already in there. And I think that the trial court was just trying to, first of all, move the parties along, and also, keep it relevant to what is in the best interest of these children as they sit here today, which is perfectly correct under the law. Sister counsel did not go into her best interest arguments. I do point out that, she did not challenge either factor H or factor J, which I think are probably the most seminal factors in this case, because it's the homeschool and community record, and then the willingness of the parties to foster a relationship with the other parent, both of which the trial court found in my client's favor, if I'm remembering correctly. I have nothing else, Your Honors, unless you have any questions for me.
Any questions? Okay. No, I don't think so.
Thank you so much.
Thank you very much. Any rebuttal?
Thank you. A couple of the things I would like to point out is that there was no CPS report admitted for either parent. All of these allegations and discussions of the CPS reports are not in the record. Neither party was substantiated for CPS, but what you see is the judge saying something about the kid saying in a CPS report that there was abuse in the mom's home, but that didn't come in. You will see no record in the evidence of these CPS reports for dad or for mom. Nobody was substantiated. There was discussions that dad was being investigated for overly disciplining the children, and mom had an allegation of domestic violence. This idea that there is in the record that the children said that there was domestic violence in the mom's home and that's why they were staying home is not in the record. There was an alluding to it by the appellee's counsel at the time, but that is not in the record. The other thing that's a little bit problematic is the judge did say, she said, I'm going to look at the record below. There's no indication of her opinion that she looked at the record below. She was not the previous record. I'm sorry, not below. She was not the judge on that case. That case did not go to trial. There is not a transcript or evidence presented of the domestic violence from before. There's no indication in here that she reviewed the PPO that was placed on Mr. Horizi at the time. And so while she may have said that during the proceedings, there appears to be no evidence that she actually did that. And if she did, I have no idea what she looked at. And it's unclear from her opinion. There's no testimony to that because it was resolved at the lower court level by a different judge who was involved with it. There was no admission of CPS. And just to go back, one of the first things that was said by opposing counsel, I think it got a little bit, I would disagree to a nature. The judicial notice was that there was a truancy case. I do not agree that there was judicial notice that the children weren't going to school because of mom, nor would I agree that the testimony didn't show dad also did not get the children to school. And so he had the child stopped attending school in late December, January of 24. He then stopped being willing to go to his father's house in February. January and February, the father could not get the minor child to school. He should have done it on a Fridays, every other Friday and every other Monday. And he was also unable to get the child to school. There are a lot of problems with this case, and it's important that people be able to present all evidence on the best interest factors. I appreciate your time. If you have any additional questions based on my rebuttal. Otherwise, thank you.
Thank you. Thank you for your appearance in court today, first of all, and appreciate your arguments and the cases submitted. Thank you. All right, I hate to do this, but this was my third cup of coffee. So I'm going to ask my colleagues to take a very brief 5-minute recess now, and we'll come back to finish the 10 o'clock call.
Honorable Court of Appeals, City of Michigan is now in session. Please be seated.
Okay, we are back. That brings us to item 15, docket number 368-735, Thomas Tarhanic versus Member Select Insurance Company.
Good morning, Your Honors. Keith Bank appearing on behalf of Plaintiff Appellate Thomas Tarhanic in this matter. This is an issue of pure statutory construction. And the reason I believe that this should break in Mr. Tarhanic's favor is the legislature's use of the word priority in section 31145 and 31146. In the legal realm, priority has a pretty well-defined definition. It means you line up. And in the insurance context, it means the insurers line up. Sure, at one level is exhausted, you do move down to the next level. And this is in the context of, the coordination of benefits between the no-fault insurer and the health insurer. That's how we view priority. If the no-fault insurer is first in priority, it covers first up to bat. Anything else that isn't covered then moves to the health insurer. And you're hard pressed to come up with any kind of priority scheme in the law that just stops at one level. In fact, I cannot think of any.
What about Mr. Saylor's argument that this language is unchanged and it didn't work the way you just described it? The priority was just, let's identify who's responsible and then we stop there.
Well, that's not necessarily true because it was all unlimited. So you only had to get to one level. Now, there may have been rare circumstances where someone was taken out of a line, but once you met one line, there was never moving down because you had unlimited and that was it. So there was never an issue of having to go to the excess. And they did keep that language. So I do think that that's important. So in that instance, it doesn't necessarily negate this argument. It just means you just never had any real practical circumstances where you would move down a notch.
So for example, if the policy here, instead of being a 50,000 policy, was an unlimited policy, there would never be moving down
Yes,
to the next
correct.
priority insurer.
And also, even if, say, you had a 250 policy here and Mr. Tarhanic also had a 250 policy, you wouldn't move down here as well because then the contractual language of Mr. Tarhanic's policy kicks in that says the maximum that you can get from any responsible insurer is the maximum limit that we provide. And that would be the 250. So there wouldn't be any kind of, horizontal stacking, vertical stacking going on. And through parenthetical 3147 prevents vertical stacking amongst priority levels. Now, in response, defendant relies a lot on 6 and 7 to say that these would not be necessary if this were a straight, or if we did have straight priority move down the line. Well, with respect to 6, I don't think that's necessarily true. And there's 2 sentences in sub 6. The first says that if there's an election not to maintain coverage or an exclusion, then an insurer is taken out of the line of priority. Well, the election to not maintain coverage under 3107D and the exclusions under 3109A2 only relate to one discrete element of PIP allowable expenses, and that's the medical, right? So even if you have an opt-out or exclusion, the insurer would be entitled to wage loss and replacement services. So that first sentence simply takes the entire policy out of priority, where it eliminates a situation where you have someone injured in a motorcycle accident and they have to go to insurer 1 for their wage loss and medical or replacement services, and then insurance 2 for their medical. So that's what the first sentence does. It simply takes the opt-out and exclusion policies completely out of priority and doesn't create this mishmash of where you're looking to discrete elements of your PIP benefits. The second sentence is a little more problematic, but their argument is that that sentence creates a conditioned precedent before you can move down the line of priority. And that conditioned precedent is the an entire level of priority being eaten up by opt-outs or exclusions. The problem with that argument is that second sentence also references claims to the assigned claims plan. And So if the condition precedent applies to the drop down in priority, it would also apply to a claim for benefits through assigned claims plan. And the impact of that would mean if you were in a situation where a motorcyclist were in an accident and no one, in a motor vehicle accident, and no one had insurance, the driver, him, none of the owners, that motorcyclist would not be able to go to assigned claims because that condition precedent also would not be met. And that seems to run completely afoul of the rest of the statute that says if you're injured in a motor vehicle accident, motorcyclists included, and there's no available insurance, you do go to assigned claims. But if you do create this condition precedent where you have to have a line of priority wiped out by opt-outs and exclusions before you can go to the assigned claims, you have an inherent conflict if you choose defendant's interpretation. And I don't think that's what the legislature intended. I think the legislature just intended to clarify how this worked in relation to sentence 1. And with respect, moving on to parenthetical 7, that's simply an anti-stacking provision across the same line of priority. It doesn't speak to moving down or down the level of priority. So I don't think either of those provisions are rendered nugatory if you accept my interpretation. And I think also you have to look a little bit at policy here too. And this is, I think, a close call if you look at straight statute. So I think it's fair to look a little bit at policy and look at the circumstances here. Mr. Tarhanic had motorcycle insurance and his auto policy through defendant. They knew he was a motorcyclist. He purchased an unlimited policy to protect himself. He's involved in a motorcycle accident. He's hit by someone with only $50,000 in coverage, and he's catastrophically injured. If you accept their interpretation, he can't protect himself. Motorcyclists can't, protect themselves through their own no-fault coverage. And essentially, motorcycle accidents become almost a kind of a lottery where the motorcyclist is at the whim of the person who hits them. And I don't know if that's a good interpretation of the law here, because, if you're on the roads, you should be able to purchase coverage to protect yourself. And Mr. Tarhanic here purchased unlimited auto coverage. And now through, just luck or bad luck, he's stuck with 50 because that's what the negligent driver had. And I don't think that's what the legislature endorsed through this statute. And the better interpretation would be to have this type of priority system where it really only comes into play when a motorcyclist does protect themselves through unlimited coverage. So I think ultimately, from the statutory interpretation standpoint, it should favor plaintiff, not only from a language perspective, but from a policy perspective. And now even getting past the policy, past the statutory interpretation, we also have to deal with the contract of insurance here. This court has routinely found that a Michigan no-fault policy can provide more coverage than is afforded under the statute. Their policy says priority shall follow this line. It doesn't have any of the qualifiers that statute does via subsection 6 or subsection 7. It just uses the word in this following order of priority and then mimics the statute, but then doesn't mimic 6 or 7 with any limitations. And if you look at the contractual language and then they're limiting on that priority, which limits their liability to the maximum of their policy in the aggregate of all insurance, then there's an argument that even if they're right on the statute, their contract provided more coverage here and does provide for a traditional type priority analysis where you exhaust the one level, you then move down to the next level. And so even if you disagree with my statutory interpretation, I think the straight contract would favor the plaintiff as well, because again, at the very least, that term priority would be ambiguous, because if you're talking about priority in the liability sense in an insurance contract, if they say they're primary and there's a priority system, you have the first up to bat liability wise, and then the second up to bat if once that's exhausted against you. So I think there's two issues here, both the statutory and contractual. I think they both break in plaintiff's favor. But I think even if you don't agree with me on the statutory interpretation, I think the contractual one should lead to a reversal of the trial court's decision. I will reserve my time for rebuttal. Thank
Any
you.
questions for
Oh,
Mr.
I'm sorry.
Baker?
I apologize.
Okay, thank you. You have time for rebuttal. Mr. Saylor.
Good morning, Your Honors. Daniel Saylor appearing on behalf of Allstate.
Mr. Saylor, I don't usually do this, but I'm going to ask you a question before you get started.
That's perfectly fine.
Do you think the legislature intended this outcome?
I don't know if they expressly considered this question of, now we're going to have one be primary and another one be excess. But what they did consider is inconsistent with that outcome. And it may well be that they thought of it and they thought, well, the same has been true forever in terms of who you get hit by in terms of their BI liability coverage. And in that respect, yeah, it's a little bit of a lottery. For years, you could be badly injured, but you had the bad luck of having somebody who only had 20,000, 40,000 in BI coverage, whereas somebody else could be more lucky and have somebody with $1 million of coverage. So it's not a shocking concept that your level of entitlement for an injury in an automobile or motorcycle will depend on
But in
how
that
much insurance
circumstance,
the
you
other
can- you
party
can-
had. I'm
You
sorry,
can-
Your Honor?
I'm sorry. In that circumstance, you can protect yourself by buying UM/UIM coverage, right?
That's true.
So it's not as much of a lottery. There's a contingency available to protect yourself in that.
Well, I think a
instance.
motorcyclist can buy UIM coverage as well. I think it's extremely expensive because of the nature of the risk of riding a motorcycle. If you're injured, it tends to be a far graver injury. But that's the nature of the beast. I don't know if that answers your question. I would have just four. I mainly will rely on my brief, but I wanted to make 4 points if I might.
Please.
The first one is that I do agree with Mr. Banka that this really comes down to a pure question of statutory interpretation. And his focus, the plaintiff's focus is on the word priority. Well, as we've pointed out, the description of priority, that's been in the statute from the very beginning when there was no notion of primary and excess coverage in terms of those different levels of priority. And what the plaintiff here is relying on is a concept of having differentiating different policies, different vehicles that could be involved as primary and secondary or excess coverage. And there was no hint of that in the statute. It wasn't added, those terms were not added to the statute when all these changes occurred in 2019. And actually, quite to the contrary, where the legislature added, and this was us getting to it first, where provisions were added to the statute to account from the new onset of limited PIP coverage, 50,000, 250, and so on, the provisions are wholly inconsistent with the notion that they envisioned this one can operate as primary, and this one can operate as secondary. And I gave a few different reasons in the brief, but I want to zero in on the one that I think there's never been a real credible response to, because frankly, I think it solves the puzzle. It shows that it can't be interpreted as the way plaintiff advances. And that is under sub 7, where it's always been, this has been the case too, that if two different insurance policies were at the same level of priority so that you couldn't say one pays and the other doesn't, they're both equally responsible, it's always been the case that they share that loss pro rata. And back when it was unlimited, it's pro rata, they just pay 50-50. Or if there are 3 involved, then it's split it 3 ways. But in a motorcyclist situation in particular, there can be frequently more than one motor vehicle involved in the accident, and under the statute, as it's always been, all would share in the payment of that motorcyclist's PIP benefits. And so they added sub 7 now. And what did sub 7 do? It said, well, if there are 2, let's say the guy is badly injured, it's catastrophic injury, over $1 million in medical expenses. And under the priorities, the obligated insurance policy is the insurer of the owner of the vehicles involved, can be plural. So you've got two. Let's say one of them had $50,000 in PIP coverage, and the other one has $250,000 in PIP coverage. The way the statute operates is that, and by its express, it says that the motorcyclist benefits that he's entitled to, benefits are payable only up to an aggregate coverage limit that equals the highest available coverage limit under any one of the policies. So that means, well, he's got a 50 and a 250. That means the total amount that the motorcyclist gets is 250, but then they have to share it pro rata. But that's the total amount he gets. So this hypothetical claimant is limited to 250,000. He doesn't even get the total of 300,000 from that level of priority, let alone move on to the next level of priority and get more benefits. So they could not have conceived that, they could not have written number 7 for that outcome and expect to have this keep going and you get continuing benefits right down the line. It's inconsistent.
So under
with the
7,
statute.
if both vehicle drivers involved in the motorcycle accident had $50,000 in coverage, they'd both be responsible and it'd probably be 25 and 25.
Right.
And under that subsection 7, that is, there's
Right.
no hint of moving down to the motorcyclist's own policy to
That's
cover
correct.
the excess, right?
That is correct. Briefly on the contract issue, this is number 3 out of 4 points I'll make. The provisions in the contract that the plaintiff is raising, this duplication of benefits, by its terms, it presupposes that the person entitled to benefits is entitled to benefits under more than one policy. But these are PIP benefits, and under the statute, under 3114.1, now generally a motorcyclist's own auto policy would be, and take that back, a person's own auto policy would be the first, they would get benefits from their own policy,
Right.
almost in any situation. But there are 3 exceptions. And one of them is if you're an injured motorcyclist. And that's exactly what 3114.1 says, that you go to your own policy, that policy applies to your injury, except in these exceptions. And one of them is when you're a motorcyclist. And under the subsection 5, his own auto policy does not apply to that injury. And so it's, the contract argument here is illusory, in other words. And finally, and this goes to the notion, even you suggest, well, what if the 2 of them were 50,000 PIP policies and they split it 50-50? It seems perhaps a little bit harsh. I don't, they could have, the legislature could have set up a situation where it made it, you know, you can have excess coverage under your own auto policy. But a couple important points about this, getting into what public policy and what maybe the legislature could or should have done. You have to remember, you buy your auto policy and maybe choose unlimited coverage to protect you when you're driving your car or arising out of an automobile accident. It's not primarily focused on protecting you when you're riding a motorcycle. That's not why you buy auto insurance. You can own a motorcycle and not own a car, and you're not going to have any auto policy. So it's a little bit of an add-on protection for a motorcyclist, albeit down the line, basically so that, you know, you don't get to the last resort and go to assign claims. If you happen, or somebody in your household happens to have an auto policy, then that would be the last priority. But it's not a strange concept to think that by and large, that auto policy is not intended to protect you in your motorcycle risk. In fact, that's why way back when the No Fault Act was passed, originally motorcyclists didn't have their own provision. They were just any other person injured not occupying a motor vehicle. And they realized, well, wait a minute, these people, if you happen to have a motorcycle, you're not going to be able to afford auto insurance. And that's why they said we got to take the primary risk from the auto insurer and spread it around to other drivers out there and spread the risk across all the motoring public so that just because you own a motorcycle, you're not going to be able to afford auto insurance. Yeah, so I think that that's the only other comment I wanted to make in terms of the public policy, that it's not really as harsh. It doesn't mean that the legislature couldn't have done it differently, but they clearly did not. Unless there are any other questions, I would just ask you to affirm the trial court summary disposition.
Any questions from Mr. Saylor? Okay.
Thank
Don't see
you.
any. Thank you. Mr. Banka, could you address the subsection 7 question? And let's take my hypothetical rather than Mr. Saylor's, because mine is closer to the facts of this case, which is it's 50 and 50, the two, and they're in the same order of priority, two drivers of vehicles involved in a motorcycle accident. And in that scenario, the limit would be $50,000, very likely split evenly between the two insurers. But the motorcyclist wouldn't then, under subsection 7, be able to move down in an order of priority to his or her own policy.
Well, I disagree with the kind of the second
Okay.
part of what you said, that 7 prohibits a drop down
Okay.
under that circumstance. I think that's in addition to, and I think what 7 does is it creates a situation where you simply can't stack up policies at the same priority level. And what that means is, when you have that situation, when you have the 250s, well, the insurer wrote the policy for 50.
Okay. So
And-
the intent is to say it's not 50 plus 50 or 50 plus 250 equaling 300. It doesn't say anything about moving down the order of priority under sub 5.
Correct. And it just simply creates a subsection where you can't stack at the same priority level.
Right.
And that's reasonable because when people purchase or when the insurers are writing these policies for specific amounts, it kind of mimics what happens in the policy language. In fact, if we had two competing 250s, by their policy language, he'd only be able to get 250 total.
Not 500.
Not 500. So, so moving down to his primary versus excess. Well, courts are often asked to interpret insurance policies that don't have any kind of language that says they're primary or excess. And that's what's going on here. So I don't think it's too far of a leap when there's the word primary and excess isn't used in the statute for this court to have to distinguish primary from excess policies. And also, I want to speak on his last point. He was talking about how, motorcyclists are kind of an afterthought. They were added on. And, you buy your auto policy to protect yourself in an automobile accident. Well, when Mr. Tarhanic purchased this policy, he got a policy that has provision for his motorcycle benefits. His auto policy has a priority provision for motorcycle benefits. So within the policy, it's certainly not an afterthought. It's a material term of the insurance document. And it says priority follows this way, and it doesn't have those limitations. So when he did purchase this policy, he did have an expectation of protecting himself for a motorcycle accident because it's right there in the language. And also I want to address the idea of, the bodily injury argument he made first. Of course, bodily injury, when you have a negligent act against you, it is, the leverage, you're not going to know their level of coverage. And as Judge Patel pointed out, you can purchase uninsured. But the difference between bodily injury and no fault are markedly different. In this state, no fault has a special place, and it is meant to give prompt, assured, consistent benefits to people injured in motor vehicle collisions without regard to fault. So it's an entirely different purpose, and that purpose cuts against, deeming it kind of this lottery system, as I termed it. So I think for those reasons, policy favors a decision in plaintiff's favor, and the trial court should be reversed. Thank you.
Final questions? No.
No.
Thank you very much. Appreciate your arguments today. It's a very interesting case and well argued. All right. That case is submitted, which brings us to item 16, docket number 370824, Caleb Mitchell Brown versus Comtock Turf Incorporated, and Attorney Schutza, who represents defendant appellant, is appearing via Zoom. There he is. Mr. Schutza, give us 1 second here. And I think you may go ahead and give us your appearance and proceed with your argument.
Thank you, Your Honor. John Schutza, appearing on behalf of the defendant's appellants. I'd like to thank the panel for allowing me to appear remotely today. We seek appellate relief on the basis of two main arguments. First, that this matter should be sent back to the Clinton County Circuit Court for a new, or not for a new trial, for judgment in favor of the defendants on the basis that either at the summary disposition stage back in 2016, there was insufficient evidence to create a genuine issue of material fact on the issue of causation in fact, or at the very least, defendants should have been granted a directed verdict at trial for the same evidentiary insufficiency. You know, the court may have noted my firm was not defense trial counsel. So when I was asked to handle this appeal, much like the court, I looked at this record with fresh eyes. And I was confounded as I read through the trial transcript because there was no evidence that I could find to support the theory that Mr. Brown had either been struck by the Comstock truck or the trailer or something in the trailer causing him to fall to the ground. I scoured the trial record more than once to no avail. There was no definitive evidence presented how the purported contact occurred or even whether there was contact with the truck or trailer. And although plaintiff had Mr. Timothy Robbins as an accident reconstruction expert, he could not offer any testimony on causation. And in fact, the court had limited his testimony prior to trial to physical characteristics of the road and talking about the Comstock vehicle. The theory that Mr. Brown propounded, in fact, shows that plaintiff doesn't even know and was unable to discern what happened. They offered a three-tiered sort of causation theory. Well, we don't know, but maybe he got hit by the truck. Oh, maybe he got hit by the trailer. Or maybe he got hit by something in the trailer. There's simply no evidence that he was struck by any of those items. And the lay witness testimony that was presented at trial pretty much dovetailed the deposition testimony that was presented at the summary disposition hearing, showed that no one could explain what had happened. Mr. Brown said he lost consciousness and didn't know what happened, although he was adamant that he wasn't hit by the truck's side view mirror. His co-worker, Douglas Reed, who I believe was the garbage truck driver, he was inside the garbage truck and didn't see anything, only saw Mr. Brown laying on Price Road. And again, Deputy Smith said there's no evidence that the trailer of the truck hit Mr. Brown, and maybe he just walked into the trailer of the truck. And again, Mr. Robbins testified he was unable to state whether the truck or the trailer struck Mr. Brown, or if Mr. Brown struck the truck or trailer. He couldn't say whether the trailer ever left the roadway. It was just, this is one of these difficult cases where you're trying to argue that something isn't there, something doesn't exist. The only thing that was established by the evidence was that Mr. Brown fell on Price Road and Mr. Brown somehow struck his head. I mentioned it in our briefing, but I believe it's noteworthy that the medical evidence that was presented at trial, the medical testimony demonstrated that Mr. Brown had given a history, I think, to his treating neurologist, that he was struck in the back of the head. Notably, there was never any testimony at trial from an expert in biomechanics to explain how it was possible that Mr. Brown was struck in the back of the head by the truck or the trailer or something in the trailer. And as far as the trailer goes, Mr. Robbins testified briefly at trial. The trailer, the bed of the trailer, was about 2.5 feet above the level of the road. So it defies explanation how he could have been struck in the back of the head by the trailer. It was equally as possible on this rainy, damp December afternoon that Mr. Brown simply slipped or stumbled, had a leg buckle on him and fell, tripped over his own feet, or suffered some loss of balance and struck his head on the surface of the road. For decades, this court and the Supreme Court, and most notably the oft-cited Skinner versus Square D case, tell us that litigants do not have any right to submit an evidentiary record to the jury that would allow the jury to do nothing more than guess. And I respectfully submit that's what happened here. In fact, I recall that defense counsel, Mr. Tower, when he was arguing the motion for directed verdict, said, Your Honor, based on this evidence, the jury is just going to be asked to flip a coin. And that's really what happened here. This was a case that should have been dismissed when causation remained an issue of pure speculation and the probabilities were evenly balanced at best. The evidence at best only established a possible correlation. It did not create a jury submissible issue as to causation. Defendants are entitled to have judgment entered in their favor for the failure of plaintiffs to proffer sufficient evidence to establish that the Comstock truck or trailer or something in the trailer actually caused his injury. I want to point, although I'm next going to be arguing about the jury instruction issue, even if the jury were allowed to find that Mr. Comstock had violated the no passing zone statute when he went around this stationary garbage truck, that alone was not enough to support a judgment for plaintiffs. As recently as, I think it's 2020, in the case of Randall versus the Michigan High School Athletic Association decision, this court echoed the well-settled principle that mere evidence of violation of a statute does not establish whether the violation had a causal connection to the claimed injury. And here there is no evidence that in going around this garbage truck, albeit in a no passing zone, that had some kind of causal connection to what unfortunately happened to Mr. Brown.
Mr. Schetzer, we don't have to reach the jury instruction issue if we agree with you on the first issue you raised, correct?
You're absolutely correct.
Okay.
I just wanted to say a word. Plaintiff cites the Model Civil Jury Instruction 10.09 regarding loss of memory. That jury instruction doesn't save the day for plaintiffs. While the jury instruction indicates that a jury may infer that a plaintiff was not negligent where there is a loss of memory, and that loss of memory was caused by the occurrence, this jury instruction is for use at trial. It has no bearing, control, or application to a motion for summary disposition or a motion for directed verdict. And furthermore, the instruction also cautions and directs that the jury should weigh all the evidence in determining whether the defendant was or was not negligent. And questionable that it's even applicable, because I don't know, the record doesn't seem to indicate that Mr. Brown actually suffered a loss of memory. He remembered he didn't strike the side view mirror. He remembered where he was standing, what he was doing, etc. I want to briefly than cover the jury instruction issue. Over objection at trial, the court gave the instruction about violation of a statute based on MCL 257.640, which is the no passing zone statute. The defense wanted the court to only instruct on 257.653B, which would have been directly relevant, and the version of that statute that was in effect in 2013 at the time of this accident requires only that a driver approaching a stationary solid waste collection vehicle reduce to and maintain a safe speed for weather, road conditions, and vehicular or pedestrian traffic, and proceed with due care and caution. There was no evidence of any negligent act or omission by Mr. Comtock. There's nothing about distracted driving or that he was speeding or he wasn't looking where he was going. The only conceivable basis upon which the jury could have found him negligent, I fear, is based on this no passing zone statute instruction. It didn't apply. And the classic case, Michigan Supreme Court case from I guess 50 years ago, the Clansack versus Anderson sales and service case, spelled out a series of, I think it was 4 factors about whether or not a jury can be instructed that they can infer negligence from a defendant's violation of a statute. And relevant here, it has to be that the statute was intended to protect against the risk that occurred. The statute's not intended to protect against the risk of a vehicle striking a pedestrian. There is no Michigan case on point that I could find, but I found a number of cases from other jurisdictions that have addressed this issue, and they all concluded, look, the risk that's being protected against by a no passing zone statute is the risk of there being a collision with an oncoming vehicle in the adjacent lane of traffic. That wasn't the risk here. Furthermore, Mr. Brown wasn't within the risk of persons intended to be protected by the no passing zone statute. The people that are intended to be protected are the occupants of vehicles in the oncoming lane of traffic when somebody performs an illegal passing maneuver. And as I think I touched on already, the statute was inapplicable because the violation of the no passing zone statute was an approximate cause of this alleged incident. There was no testimonial or physical evidence that passing in a no passing zone caused contact with the truck, the trailer, or anything in the trailer.
Mr. Schutz, I think we have a firm handle on your arguments, and you will have time for rebuttal. Is there anything else you feel compelled to tell us right now?
No, I think I pretty much covered it. Thank you.
All right, thank you. Mr. Hicks.
May it please the court, Steve Hicks on behalf of plaintiff appellee Caleb Brown. I wanted to address basically 2 major points. I'm going to reverse the order since they didn't come up in counsel's argument in the order that they did in the brief. So let me go to the factual causation issue and what evidence there is to establish factual causation. Basically, I think defense counsel seems to disregard the circumstantial evidence that's here in this case, and with a focus on, I think his word was, there's no definitive evidence, and by that I think he means direct evidence. Let me tell you what the evidence in this case does show. First of all, to start with the fact that the plaintiff does have, and there's pictures of it in the brief, of this laceration to the back of the head. He's clearly been struck in the back of the head. Now, did this happen by falling down, I guess, defense counsel posits. Let's look then at the plaintiff's testimony in this case. What did the plaintiff say he was doing as this vehicle comes into the lane of travel next to him while he's standing next to this garbage can? He knows there's going to be some spray coming off of it. The weather conditions are bad, and yet this gentleman is passing. And he turns his head away to avoid the spray, consistent with laceration to the back of the head. What does the driver who's in the sanitation truck say happened? Well, I saw him standing there. I saw plaintiff standing there next to the bin, and then the vehicle went by, and then he was down. So all those things are consistent. And then what does the defendant say in this case? What is the defendant's testimony about happened? Defendant's testimony is, I looked right at him. We made eye contact. My vehicle was passing. He was in a safe position. He wasn't moving. And yet, as Mr. Reed, the driver, testified, after the vehicle passes, he's down. Quite frankly, that's more than enough circumstantial evidence in this case to establish what happened.
Well, isn't it just as likely that he slipped and fell? I mean, you know, you might say there's circumstantial evidence of that, or that he
Slipped and-
walked into the truck because he was turned this way and maybe he
Slipped-
thought the truck had passed by and he walked into the roadway.
Slipped and fell while his head is turned to avoid the spray and he's not moving. The vehicle that is coming, and I think it's important to picture this vehicle too, as it's coming by him, because we're talking about a sanitation truck in the lane of travel, which defendant has testified takes up the lane of travel. So to pass it, he's got to get into the opposing lane. What is this vehicle that he's driving? It's a Ford 350, big truck. And what's he hauling? He's hauling a 40-foot flatbed trailer, gooseneck trailer. And defense counsel is right, the bed of the trailer is about 2.5 feet off the ground. Never mind the fact that it has a gate on the end that extends upward to keep, you can drop the gate down to ride the vehicles off. So that's there as well. Never mind the fact that the testimony is he has things on the trailer. It's a little unclear what exactly he has on the trailer because he's been all over the map on that issue. But he has at least the Polaris vehicle and the attachment that went with it. He's also testified that, yeah, if I had tools with me that day, it would have been a shovel that I would have taken along. And then there's a second vehicle and attachment, a tractor with an aerifier that could have also been on there, although it's unclear from his testimony whether it was or what it's not. I don't believe that we have to establish he was struck in the head by the shovel, the aerator, any number of these items.
You have to establish that he was struck in the head by something.
He was struck in
Other
the-
than the ground.
I don't think there's any question he
There-
was struck in the head.
there's
There's
no-
a laceration. to
Right,
his head.
yeah, which could have been when he fell to the ground. There's no testimony from your plaintiff that the truck hit me. There's no testimony from the driver of the pickup truck that he hit the plaintiff, obviously. There's no testimony from the driver of the garbage truck that he witnessed the truck hit your plaintiff. And even your own expert can't say that that's what happened.
And
So-
frankly, I don't think that's all that unusual in a case that's built on circumstantial evidence. The fact is, client gets hit in the head, has amnesia. I don't understand what the claim is, that it's not a loss of memory case. He clearly has no memory of what happened. And therefore he does get the presumption under 10.09. Presumption or inference. I've always been a little confused on that because it's titled.
So is the jury instruction between the title and the body, right?
Well, it's titled presumption, but it says inference. So I'll leave that to Chief Judge Godola to correct at some point since it's on the committee.
Gotta get that fixed.
But I think that's an important consideration there because it is an inference that can be taken on top of all of this other evidence that's there of what happened. Quite frankly, I think it's more than enough in this case. And there are the other injuries that he sustained. It's not, if it's this fall that hurt him, he fell and he struck his head. How do we explain all the other injuries that he sustained in this accident that are consistent with being hit in a traumatic fashion? But if I could just return real quickly because I think it's important, the negligence component of this, because it plays into causation. We've all been down rural 2-lane highways. They are often narrow. This one was narrow. We're talking about an individual who's no longer at the sanitation truck. He has to cross over to the other side to get the bin. And this suggestion from defense counsel that there isn't any negligence here but there couldn't be any negligence other than maybe this passing in a no passing zone. The due care and caution aspect of 257, 653, I think just cuts the legs out of that argument. Because who, in using due care and caution, sees a gentleman doing his job, picking up trash, standing next to the trash bin, stopped, not moving, in a safe position, and says, you know, I'm just going to follow this SUV through because I'm sick of waiting. He only needed to get to Clintonia Road, which was just down the way, and then he was going to take a right and go to the high school. I don't think that's due care and caution. The notion that there's no negligence in this case is frankly a little shocking to me, but I think it also informs our understanding of causation here. There is not a lot of room to maneuver there. And all of the testimony is consistent with the fact that he was struck because, you know, he's got the laceration in the back of the head. It's circumstantial evidence. I'll give you that. I don't have direct evidence. I don't have Mr. Reed in the truck saying, I had my eyes on him and bam, I saw the truck hit him. We don't have that. So if I could just, unless there's further question on that, let me turn to the jury instruction question because I did want to address that too. This is the 12.01. If there's a statute and you violated it, you can infer that they're negligent. Defense counsel in both their briefing and then later in argument today made a point that that the no passing zone is really, perhaps in his opinion, the only thing that the jury could have concluded that would have led to him believing that the defendant was negligent. I've kind of explained why I think that's exactly wrong. I don't understand how you could possibly be using due care and caution when you're going to shoot that gap between a sanitation worker in the rain, bad conditions, with a vehicle taking up your lane, and do it right behind another SUV. I just don't know how that could possibly be using due care and caution, even if your speed was what he says it was. Reed says it was 20 to 25 miles per hour, which is pretty fast given that you're shooting through that gap. The defendant, of course, says he was doing 5 miles per hour or something. But to address the instruction, so with regard to the instruction, I don't think there was any problem in giving 257.640, which is the no passing zone instruction in this case. With regard to the notion that, well, he's not in the scope of the people that are intended to be protected in a no passing zone. To some extent, I take some personal offense at that because I spend a lot of time on these rural highways. I do a lot of biking. I do a lot of running. I do a lot of walking. That puts me out there. In any one of those zones, I am exposed whenever somebody is passing in any one of those zones. So to say that, oh, this is just a statute that's designed for motorists, or it's only designed for collisions.
But counsel, in the circumstances of this case, Mr. Brown knew that the SUV and the truck with the 40-foot trailer had been following the garbage truck, as he said, for miles. He watched as the SUV passed. He watched as the truck began to pass. Mr. Comtock said they met eyes. He was very much aware of the truck passing. He turned his head so he wouldn't get splashed. How did the crossing of the yellow line have anything to do with what happened here?
Well, I don't think in terms of giving this particular, the question that the defense has raised is, was this even within the scope of what, of the people that it was designed to protect?
The zone of protection.
Yeah, and I would say that anytime you have a pedestrian on the roadway, whether it's, you know, if the particular facts are that he was standing here, he was standing there, et cetera, whenever you put a vehicle into the opposing lane, fundamentally, you're putting it much closer to the pedestrian. So that's, you know, that's, I think, the factual link here. And that's why I think it's true for any type of road users. I mean, bicyclists are going to be traveling with the traffic.
But in this case, that would be true whether there was a yellow line there or not, wouldn't it? I mean,
well,
how did the violation of that statute have anything to do with what happened?
Well, the sight lines, there is a reason why no passing zones are where they are. And it's because sight lines are poor in those areas.
But not from across the street. It wasn't. It didn't impact Mr. Brown's sight line to the truck. or the truck sightline to Mr. Brown, did it?
Well, whether it impacted the defendant's sightline, he would say no, because he made eye contact with him as he was passing him. Whether he saw him before that, recognized he was there, I guess he testified that he did. But I don't know that I buy.
I'm sorry, go ahead.
I don't.
Just say, he said he saw him run across the road after he supposedly started to run in front of the SUV and it slammed on its brakes. And then he crossed the road, he saw him cross the road, he saw him standing in a safe position and he proceeded.
That is what he says. That is not what Reed says. That is not what the plaintiff said. They both say that the SUV came through and then he crossed over to the other side. But to go back to your point, listen, if you don't think 257-640 should have been in there, I think I've already explained why it doesn't matter. If it's instructional error, it's not anything that affected substantial justice in this case, because they're dead to rights. They have a problem with 257-653. There's no way this individual, Comstock, was using due care and caution doing what he did that day. And therefore, he would have been found negligent off of an inference under 653, regardless of whether 640 was there or not. So even if the court should disagree with me on 640, I think you still end up in the same place with clear negligence. And frankly, I'm a little surprised by the negligence argument that is in both the briefing and that we've seen today, because when they moved for summary disposition in this case, it was about causation. It was the first argument that defense counsel made. It was only when the instructions came up and they didn't like the instruction and that issue came up that they said, oh, we're also fighting on negligence. But you notice there wasn't a summary disposition motion in this case saying there's no way you can find negligence in this case. There wasn't a directed verdict motion on negligence. There wasn't a JNOV saying, hey, there was no negligence.
Well, I think the fight is over whether or not there's a presumption of negligence. So they, maybe not,
Presumption.
maybe defense counsel theorized that I'm not going to win on no negligence on summary disposition, but then we get to the end of the case and we're talking about the jury instructions, and now the question of whether or not a presumption arises comes up.
But long before that, when they moved for summary disposition, the evidence is the same. All the points that you've raised, questioning the circumstantial evidence and not having direct evidence, it's all the same. And you don't see a motion to dismiss this case on the grounds that there isn't any evidence of negligence.
I was
and
just going to say,
cut.
As a runner and cyclist myself, I agree with you in the abstract about the statute potentially taking into consideration pedestrians who are oncoming or someone standing on that side of the road, but we're not dealing with this in the abstract. We're dealing with the facts of this case, and I think Judge Booth.
If I understand what you're saying, Clancy basically outlined three different things that you look at when you look at whether it's appropriate to give statute as an instruction. The first one is, is it foreseeable that the result of the violation could be this? Is it foreseeable or not foreseeable? Is this individual within the scope of what's, and then the third one is essentially approximate cause analysis. So I think that's where the court seems to be focused, is on the causation issue. I've made my argument on that point. I think the evidence is more than sufficient in this case. And to affirm the jury's verdict in this case. But the simple point I was trying to make with regard to negligence is, I don't think you could have a more clear-cut negligence case than this. And I don't think that you need to have direct evidence in every case. I think when you have the circumstantial evidence that we have in this case of what happened out there, the jury is entitled to conclude that yes, Comstock struck him. Something on that vehicle, whether it was the shovel sticking off, whether it was the gate that raises up far higher than the bed of the trailer, or whether it was the vehicles that he had on there that had attachments. One of those things struck him.
Maybe.
So, well, I disagree with you on that point. So.
All right. Anything else for us,
Thanks for your
Mr.
time.
Hicks? Thanks.
No, I don't.
Okay. Mr. Schutze, any rebuttal?
Just very briefly, the plaintiff's argument that the giving of the instruction based on the no passing zone statute, and they say this in their briefing, was at worst harmless error is outrageous. It constituted prejudicial and reversible error because the jury's finding of negligence, I submit, could only have been the product of the erroneous instruction. The complete absence of any direct or circumstantial evidence of negligence by Mr. Comstock, no speeding, no distracted driving, etc. And this idea that he didn't proceed with due care and caution because he chose to, I think the word used was shoot through this gap, is nonsense. The testimony showed as he proceeded, he saw by his own words, Mr. Brown in a safe zone. He wasn't standing in the road or close to the road. He was in a safe zone. Why wouldn't he be allowed to proceed with due care and caution under the speed limit and go around this truck? I think the court should not even reach, frankly, the instruction issue. I think the causation issue is dispositive, and we ask that the court send this back to Clinton County for entry of judgment in favor of the Comstock defendants.
All right. Any questions for Mr. Schutze? All right. I don't think so. Appreciate your arguments today. The case is submitted. Mr. Hicks, I'm glad you found your way to the courtroom here in Lansing today. You may recall, what was it, about a year ago, I showed up for my case call in Detroit, and I was happy. I've known Mr. Hicks for a long, long time. And there he was standing there at the security desk waiting to come through. Oh, he must have a case today. Well, he informed me that his case, and even though he practices law in this area, the case was actually to be argued here in Lansing, and he had driven to Detroit. I said, don't worry about it. They'll let you argue by Zoom, which I think they did. So.
They did, but you wouldn't loan me a computer.
Oh.
We're all secure. I had Eric Rasucci.
Oh, very nice. Oh, that was nice of Eric to do. I understand the reason.
Mr. Rasucci.
Yeah, right. Okay, I'll thank him on your behalf again when I see him next.
I'm thankful for Zoom, Your Honor. It's prolonged the careers of old goats like me. So
right, yeah, true. And we're grateful for that. All right. Thank you very much. The case is submitted. All right. That'll take us to item 17, which is the first item, I believe, on our 11 a.m. call. And that is docket number, it's consolidated cases, docket numbers 374-790 and 374-792, in re A. Alman Minor. Mr. Ambrose. You're endorsed on one of the two.
I represent father.
Right.
I believe on docket number 17. So
You
it's
are.
a Ronald.
Yes, you are. Yeah,
Okay.
you're in the right place
Yeah.
at the right time.
You know, it's one of my biggest fears of what you just said is
Right.
I check
That
and
would
double
happen.
check and triple check every time.
We've had judges do that too.
I can only imagine Mr. Hicks' panic when
Well,
he
and
realized.
They've been changing it up because sometimes Detroit cases will be heard in Lansing and vice versa, which they never used to do
Right.
before, I thought, but.
Okay.
Yes, Ronald Ambrose appearing on behalf of Mr. Alman. He's the father of this child, and it's a very sad case because this infant was taken from the hospital 2 days old. Our position in this case is that the initial petition should never have been filed because there was no finding of neglect of a 2-day-old child, infant, and that even after the petition gets filed, there is no evidence of any type of chronic neglect by Mr. Alman in this case. And I ran down the statute, and I outlined why the court made an error in adjudicating this case as it did. I really don't have anything to add to what is written. I'm not opposed by anybody today. So if you have any questions, I'd be more than willing to answer them. Otherwise, I will stand
Questions
on
for
my
Mr.
brief.
Ambrose? I don't think we have any.
Okay, appreciate it. And what we are seeking is just a reversal of the trial court decision. All right, thank you.
Thank you very much for your appearance here today, and those cases are submitted. That brings us to item 18, docket number 375795, in re A. Dixon Minor. Ms. Ayler Smith, you're up again.
Is it still morning?
It's just now 12 noon.
Okay,
So-
good afternoon, your honors. Jordan Ayler Smith on behalf of the appellant mother. Just as the case before me, I am obviously not opposed this morning. I'm mostly going to be relying on my brief. I did just want to mention the Boursaw case, which we cite in our briefing in the argument regarding the statutory grounds for termination. I do believe that case is very instructive, and I would encourage this court to obviously read it before deciding this matter, because I think that it helps with determining whether appellant mother in this case was given a meaningful opportunity to comply and benefit from her service plan. Obviously, your honors deal with numerous termination of parental rights cases. I know that that's probably, I think it's the bulk of your docket. I see parents who, you know, are afforded multiple years. I think I've had a case where the parent was afforded 6 years to work on their case service plan. Mother in this case was afforded 12 months to try to cure housing, a drug problem, lack of employment, lack of transportation, mental health issues, pervasive physical health issues.
Of course, that's more than twice the amount of time permitted under the statute, which is 180 days, isn't it? I mean, if 12 months would be a year.
You are correct, Your Honor. Under the statute, there is, I believe, is 182 day review. But in this case, the child was placed with relatives, and under the law, there is no requirement to ever petition for termination if the child is placed with relatives. I cited that in our briefing. I can't remember the statute cite off the top of my head, but I think that in this case, you have a mother who cured or was working on curing all of her barriers to termination or to adjudication. She had found a job, she had stable housing, she was actively involved in multiple different types of counseling. I think that in this case, we're looking at a termination that, yes, while 12 months is longer than the 182 days, I think that we're seeing a pattern in this case where mother was actively working. She was testing, you know, she was still drug testing. She was testing less positive than she had been at that point in 2024. I think that she was making very good strides with her case service plan, and she just needed some more time. In terms of the best interest argument, I'm citing Mason for that one, and I don't want to belabor any facts here for your honors this morning or this afternoon, whatever time of day it is, because I know that your honors are familiar with the case. So unless you have any further questions for me, I would just ask that this court reverse the trial court's order.
Smith, okay.
Thank you so much.
Thank you very much. Appreciate your appearance here today, and the case is submitted. All right, that brings us to item 19, which I think will be submitted on the briefs. Docket number 373055 and 373058. In re Chapman Estate and in re Leonard and Frida Chapman Trust. And that will be submitted on the briefs. And with that, we are adjourned.